Well, hello, everyone. Welcome to the ACS conference 2023 and to this breakout panel on the new era of antitrust. Really excited to see so many people here in person, and we're thrilled that we have a number of people joining us also virtually on video. So welcome to everyone. I'm Ganesh Sitaraman. I'm a professor at Vanderbilt Law School and director of the Vanderbilt Policy Accelerator for Political Economy and Regulation. I'm excited to be the moderator for what's going to be a terrific panel with really amazing speakers. Before we get started, a few housekeeping items for folks. First, I want to thank ACS and all the staff here at the hotel for all their work in putting this event together. We really appreciate all of the work people have done. A lot goes into making these things a reality. Second, for those of you who are signed up for this session to get CLE credit, the CLE code is PINE, P-I-N-E, and I will tell you the second CLE code later in the session. Third, I'm excited to introduce our panel, and I'll introduce all of them at the beginning and then give them a chance to talk. Directly to my left is Zephyr Teachout, who is an associate law professor at Fordham, and maybe is not an associate law professor at Fordham.
She was from 10 years ago.
This was also changed. She is a professor at Fordham Law School, though, among other things, but has written terrific books, including on corruption and on antitrust, and is really one of the leading advocates around antitrust in the country, and has considerable experience both on the academic side, on the legal and policy side, but also in politics as a candidate for governor of New York and for Congress in New York as well. To her left is Diana Moss. Diana Moss is president of the American Antitrust Institute, which is, for those of you who don't know, one of the really leading antitrust organizations in the country. And as a result, is just a deep, deep expert in many of the issues that we're going to be talking about. Importantly, she also worked at the Federal Energy Regulatory Commission, and so has real experience in the federal government as well, thinking about how agencies engage with questions of regulation and competition. And to her left is Sandeep Vaheesan. Sandeep is the legal director at Open Markets Institute, which is one of the leading antitrust and competition advocacy groups in Washington. They do a significant amount of both legal work and research, which he leads. He also worked for some years at the Consumer Financial Protection Bureau on regulatory issues, among other things. So I'm really excited to have this great group here, and we'll start maybe with Zephyr, and I'll ask everyone's going to give some opening remarks, and then we'll open it up to a broader conversation and to questions. But before we do that, I want to set the table a little bit for folks maybe who don't live and breathe antitrust all the time like some of us do. And the thing that I'll say is I think we're in a really exciting moment for people interested in antitrust. In terms of the big arc of history of where we are right now, we've really been in a period for about 40 years in which the view of antitrust was defined quite narrowly in terms of economics, as focused on efficiency and consumer welfare. And this was an approach to antitrust that in a lot of places said, we shouldn't do as much antitrust enforcement. We should let mergers go through. We shouldn't be so worried about consolidation. And the consequence, of course, as all of us know, over the last decade plus, is that we've seen massive consolidation across virtually every sector of our economy. Often people talk about big tech or big banks, but as many advocates have shown, you can even look to areas like cheerleading companies and find consolidation. You can go to rental car companies and you think you're getting many different brands when you're at the airport looking at them, but they're actually a very small number of companies that happen to have multiple brands within their same parent. So we've seen this across a whole bunch of different areas. And what's really exciting is that really in the last 5 years or 7 years, we've seen a real shift. And people have decided and understood that consolidation is a real problem. It's a problem for consumers. It's a problem for businesses. It's a problem for competition, for inequality, for resilience. And that we need to think about what it will take to have a more competitive economy. And that part of that's going to mean serious reforms in the antitrust world. And in the last few years, specifically, I think we've seen real change on this politically. The Biden administration came into office and made a real commitment from the beginning on competition policy. They issued an executive order on competition that was quite expansive, I think, unlike anything that we've seen before from a presidential administration. They appointed Lina Khan to be chair of the Federal Trade Commission, Jonathan Cantor to run the antitrust division at the Justice Department, Tim Wu to be the person at the National Economic Council working on competition policy. And these were, I think, seen by most people rightly to be people who were interested in moving forward on making our economy more competitive and who understood that competition is actually good for economic growth, for development, for commerce, and for addressing some of the bigger challenges we face in terms of economic inequality in our country. So that's where we are at this kind of moment of big change and a lot happening in a very short period of time over the last few years to really move beyond the last 40 years. And so with that, I want to turn to our panel to tell us a little bit more about how, from each of their perches and what they work on, what they see, how they see this moment, how they see the changes, and I think we'll drill deeper into what's going on in these different areas. So, Zephyr, why don't you start us off?
Thank you very much. Thank you to ACS. I should say off the bat that my current job is that I'm a senior counsel for economic justice at the New York Attorney General's office, and nothing that I say here reflects the views of that office. I am here as a no longer associate, as a law professor at Fordham. I want to just start by underscoring what Ganesh was talking about. I think the revolution that we have seen in the last 2 years is one of the most significant political, economic revolutions at the level of democratic society that we have seen in a long time. In 1980, when Reagan brought in his deregulatory regime, even with the marriage of corporate power, right-wing religious advocates, he could not build a political base to pass over power to giant corporations and to grant to corporations the governing power that they desired. So instead, he used the regulatory state to gut the regulatory state. And he did so at the level of practice, by the judges that he appointed, by the regulators that he chose to bring in, who then chose to simply not enforce the law. There are parts of the law that have laid fallow for 40 years. That non-enforcement through Reagan and then Bush, by the time Democrats got back in power, was crystallized and calcified into dogma. That antitrust was technocratic for a handful of economists to make decisions about what kinds of particular behavior might possibly lead to higher prices. Antitrust was taken out of the political conversation. And even the left, in debating about corporate power, talked about corporate power as if this whole suite of tools didn't exist. And of course, there are significant exceptions, but you see through the 90s and aughts a sense of a kind of just absolute absence of a anti-monopoly vocabulary. What we've seen in the last 2 years, coming out of really a post-crash politics and an effort of advocacy groups such as OMI, law professors like Ganesh, American Economic Liberties Project, Institute for Local Self-Reliance, local state attorneys general, and popular demand, a real popular understanding, and the polling is out the roof on this, that corporations have too much power, that there is a democratic problem with governance in our society. You saw this effort over 12 years. In the last 2 years, you have seen a total transformation. The Biden administration is the strongest anti-monopoly group in the country. It's nice when it's the White House. And it is not just, and we're going to talk about some of the things the FTC is doing and the DOJ is doing, but I think it's really important to set the stage that this is not an agency-specific approach. It is a vision about the appropriate relationship between corporate power, freedom, and democracy. It is a vision about what the regulatory state can be. It is a vision that part of the job of government is to stand between corporate tyranny to protect people from being exploited, extorted, and manipulated. And it is an understanding that an essential job of then these agencies is protecting democratic freedom. So I'm dwelling on this because we will turn to the technical part, but we have to embrace that paradigm change, because it is only as strong as those who continue to carry it on. We must continue to insist, not just do the work, and we're going to do the work, but continue to insist that we can't let technocrats recapture antitrust, and they're going to try, and they already are trying. So in terms of specific things that have happened, I mean, you've seen the sort of sea change at the FTC. It is 2 years ago next month that Chairwoman Khan was appointed. That was a brilliant and brave move by President Biden appointment. And it has led to, among other things, the right to repair flourishing. I don't know about you, I live in East Harlem. The local stores now can repair your phone because of the FTC being clear that you can't, that the big companies can't control the repair shops. It has led to a sea change. I mean, if you want to see the power of this FTC, you got to read the Wall Street Journal. They have choice words for the chair. But if you look in the business press, it has led to a sea change in M&A behavior. Mergers and acquisitions are now scrutinized much more intensely. They are scrutinized looking at past bad behavior of companies. And the mergers are looked at through the lens of labor, something that has not been done, looking at what the labor impacts of firms coming together. This is a total sea change in corporate behavior. You've seen the proposal that's with the Competition Authority, with the rulemaking proposal on non-compete agreements. Another sea change, one that I think you can see President Biden cares a great deal about, but works to right the power relationship between workers and big companies. In the DOJ, you see the DOJ bringing Section 2 cases that basically operated as a non-law, an area of lawlessness for years. And the DOJ is bringing those cases, and yes, sometimes they're facing a hostile court. But for too long, there was a kind of passive belief that, well, it's not really worth bringing the case because courts might not like it, and maybe they'll have too many economists. But you have a DOJ that is committed to law. And there's a revival in this area of law, which, by the way, is a key tool of equality in a society with concentrated corporate power, that law must mean something. So you see the DOJ bringing criminal cases. Monopoly is theft. Price fixing is theft. There is a different understanding of the nature of the harm at the DOJ. And then you see President Biden not only issuing this extraordinary executive order, but setting up a competition council that meets regularly and reports directly to the president. I think twice a year. The DC people probably know better than I do. Twice a year. Reports directly to the president about how agencies across the administration have an obligation to look at what they are doing through the lens of anti-monopoly. What this means is that you can afford hearing aids now where you couldn't a year ago. You can go get over-the-counter hearing aids, changing social life for isolated Americans because of competition policy. These are agencies that don't even understand the way in which power works in their own industries, and Biden has said, figure it out. So this whole of government approach that Biden is taking is, I think, one of the most exciting things that's happening, because antitrust is one part of anti-monopoly, and anti-monopoly is non-discrimination rules. Anti-monopoly is making sure that companies can't extract maximum value from workers, but workers actually have a place at the table. Anti-monopoly is making sure that companies don't get to just merge, raise prices, and float on, as economist John Quokka showed our last 30 years of policy had allowed for. So it is, I don't know how many of you here are students. I don't know how many of you here are in, at least one student nodded. Okay. It's one of the most exciting areas to go into work right now, because if you look at what the Department of Ag can do, or the Department of Transportation, there are powers that have laid fallow for generations, and you now have a president who is committed to fighting for workers and small businesses against corporate exploitation. Like, this is a moment to be joining this movement, because, as I said, it's only going to last as long as we continue to build power around it.
Thank you. That was great. To Diana, and you work here in DC in the really heart of antitrust and have for a long time. So how do you see these shifts, and what do you see as the important debates and dynamics that we're seeing right now?
Sure. Thank you, Ganesh. Good to see Sandeep. Good to see you, Zephyr. Good to see all of you. This is an important moment that we're in. I would argue that the progressive movement for stronger antitrust enforcement started in the late 90s. AAI is 25 years old, and we were founded on the basis of pushing back against conservative ideology that had infected the courts with conservative judges, that had infected political administrations, where the public was largely locked out of any sort of productive discourse about the importance of markets, the importance of how competition supports markets, the notions of entrepreneurial and consumer freedoms, and how that all supports democratic principles, right? Those things are all tightly connected. So whenever somebody takes issue with something that I'm advocating for, my response is always, we all benefit from markets, all of us. That is a central pillar of a democratic society. So if you're not for markets, it's not just the left end of the political spectrum that's advocating for markets. It should be everybody, which is really what makes us very concerned about the lack of bipartisanship in Congress on issues or matters of legislative reform to modernize the antitrust laws, to clarify them, to strengthen them. It just isn't getting any traction. And so, we have reports out there saying, oh, you would never want to get involved in markets or regulate them. It's a buzzsaw. It's gonna reduce incentives to innovate. It'll chill competition. That is a very stock right-leaning response to more vigorous antitrust enforcement. But the bottom line is everyone benefits from markets and from competition. So AAI was really founded on those principles to push back against this conservative ideology. And Ganesh, you're right. We're in the trenches. We're lawyers and economists and institutional experts, and we do multidisciplinary analysis. bringing in consumer psychologists, engineers, technologists, data science people. We think antitrust in this era would really benefit from more than just having lawyers and economists huddling in a room about how to litigate a case, for example. So with that preface, I do want to commend the Biden administration for the whole of government approach. It's not a new thing. Just like the progressive movement didn't start 3 years ago, it started 25 years ago. Whole of government has been around for a long time. It just hasn't been acted on or implemented in any coherent way. When I was at FERC, Federal Energy Regulatory Commission, I was the liaison between FERC and the DOJ and the FTC and the Department of Energy. We had meetings where we sat around talking about competition issues between all of those federal agencies, trying to figure out ways to support each other, to bootstrap regulation and enforcement to make sure there were no conflicts that would actually harm markets or harm the competitive process. So not a new concept by a long shot. And we do have some leading agencies really doing great work in that area. USDA, for example, is one of the shining examples of the whole of government approach. DOT, possibly one of the most captured regulators in the U.S. economy. Judge standing up and looking surprised that DOT was going to block the merger of JetBlue and Spirit. Wow, what a concept. DOT actually using its authority to do that. He did look surprised too. It's interesting. FERC, not playing the whole of government game, actually came out recently with two major rulemakings supporting rights of first refusals by incumbent vertically integrated transmission companies. You get the right of first refusal to build new transmission lines. That's not a pro-competition rulemaking. Another rulemaking, natural gas pipelines can show demand for the need for new capacity and grant certification on the basis of affiliated contracts. Wow, doing business with your affiliates and having a hammerlock on a gas transportation system. That's not pro-competitive. So we're hoping to see more of this, obviously, and I think the Biden administration is really committed to that kind of thing. But shifting really quickly to, again, we do work in the trenches. We have a very active amicus program in federal court, sometimes in state court. We talk to Congress, we talk to the agencies, we talk to the media. This is an all-in, multi-tactic approach to promoting stronger and more coherent competition enforcement. And I would say that, merger control is really the first line of defense. It is the first line of defense against high concentration, tight oligopolies, cartels, and dominant firms. Why? Because it's forward-looking. Mergers have to be approved before they happen, and that's the incipiency standard, right? Preventing badness from occurring before it actually occurs. So if we have strong merger control, then we won't eventually have to deal with tight oligopolies of firms like the beef packers, right? Like the fact that we have two major PBMs, pharmacy benefit managers, like the fact that we have three major wireless national facilities-based carriers in the United States. If we had stronger merger control, then we wouldn't be dealing with those tight oligopolies and emergence of dominant firms. So very heartening to see the DOJ and the FTC working hard on strengthening merger control. More cases. Let's bring more cases. That means the agencies they need more resources. They need appropriations. We're seeing more novel theories of harm. Take, for example, the Meta Within case, right? That was a potential competition case in the development of VR fitness applications. In this case, however, the potential competitor was Meta. It was the big company. It wasn't the smaller rival, nascent rival on the outside. Look at the recently filed case in Amgen and Horizon, big pharmaceutical company. Interesting theory of harm around the leveraging of rebates, right, to get on PBM formularies. That is not a theory of harm, as we say in the economics profession, that we've seen in a pharma case. And I'm glad to see these new theories of harm. And there are some wins. There's been some losses. We saw a big labor case in the Penguin-Simon Schuster merger. Not the first time a labor market has been defined, but one of the first times where the agency prevailed on a labor market theory and successfully forced the merger to be abandoned. We're seeing More aggressiveness in negotiating with parties. No, we want you to abandon your merger. No, we don't want to see your remedy. So please abandon the merger. Deep-pocketed defendants are taking the agencies up on that. And they're saying, okay, we'll take our remedies to federal court and we'll see you in court and we'll litigate our fix. That is not a good development. We do not want remedies, merger remedies litigated in federal courts. We want them dealt with by expert antitrust enforcement agencies. So all in all, we're seeing positives. We're seeing movement. We're seeing some strengthening. We're seeing a more aggressive enforcement. But remember, antitrust is played out in the courts, and it's like turning around the Titanic, right? It will take a long time for new concepts, more progressive concepts to seep their way into the case law. So importantly, the agencies not only have their litigation programs, but they've got their policies, they have guidance, they do advocacy, supporting private enforcement, for example. We're really very much an advocate for that complement of tools in the toolkit to be wisely and actively pursued. And I think the reason why this is so important is we want reforms to stick. When the Biden administration is gone, when the enforcers at the DOJ and FTC are gone, as everything turns over, we don't want to lose the momentum from a more aggressive competition policy. And that's why the whole of government approach is so important. That's why we need all the tools in the toolkit. We need antitrust law, we need labor law, we need intellectual property law, we need privacy law, we need sector regulation, all working together to support the competition mission. And I would really warn against attempting to load up antitrust enforcement with too many tasks, too much for what it was designed to use. So this toolkit approach is going to be very important moving forward. So I think I'll leave it at that.
Perfect. So let's turn to you, Sandeep, and you've been working a great deal on a number of things related to current developments, particularly in how the FTC and DOJ are thinking about a lot of legal questions. So I would love to hear your thoughts on where we are now and what some of these current debates.
Sure. Thanks so much, Ganesh, and thanks to ACS for the invitation. It's truly an honor to be here alongside Ganesh, Zephyr, and Diana. So I'm going to offer a theme of qualified optimism. I think the rhetorical shift that has happened since the start of the Biden administration in January 2021 is impressive, but we're still very, very much in the early stages of translating that rhetorical and ideological shift into law and policy. If this were a baseball game, I might say we're in the bottom of the first, or if I'm being generous, top of the second inning. So I'll start by discussing what I think is maybe the single most exciting thing that has happened in anti-monopoly world since January 2021, and that's the Federal Trade Commission's proposed ban on non-compete clauses, which was announced in January, so about 4 months ago. Open Markets led a labor and public interest coalition that petitioned for this rule in March of 2019. So this was tremendously gratifying to see. The FTC proposed a complete ban on these contracts, no exceptions based on income or line of work, categorical ban, bright line rule, no non-competes going forward. And I indulge in some self-congratulation, but this was very much a collective effort involving labor organizations, other public interest organizations, reporters, economists like Evan Starr, who published a number of path-breaking articles documenting the negative effects of non-compete clauses. Of course, this is just a proposal. The FTC still needs to review the tens of thousands of comments it received and finalize a rule. I hope it finalizes a complete ban. I hope it doesn't buckle under pressure from industry. And just as importantly, I hope the FTC finalizes the rule in an expeditious manner. We don't know how things are going to go next November, so urgency is really important. Of course, I hope the non-compete rule isn't. There are many, maybe even dozens of worthy targets for FTC rulemaking. I'll just mention a couple. So I think the FTC should be doing a rule on exclusive dealing by dominant firms. This is a common strategy and tactic used by monopolists and other dominant firms to lock up their markets. So Google, for example, pays Apple billions of dollars every year not to install non-Google search tools on iPhones and iPads. UFC, the MMA league, prohibits its fighters from fighting in contests organized by rival leagues. Mylan famously prevents or encourages pharmacy benefit managers from not carrying rivals to its EpiPen. So this is a practice that's found across the economy, something that the FTC should target through a rule. And in fact, the Open Markets Institute petitioned for such a rule in July of 2020. I think another good target for rulemaking would be below cost pricing or predatory pricing, as some of us call it. Uber, Amazon, many other companies in Silicon Valley use this pricing strategy to take over markets. In fact, you could say this is one of Silicon Valley's common business models. The venture capital funds, loaded up with money from the Saudi royal family and others, say we're willing to burn through billions of dollars in the short term to take over markets and recoup that short-term loss through long-term monopoly profits. And unfortunately, the Supreme Court has made it extraordinarily hard to challenge predatory pricing, which is why many venture capitalists have decided this is a good way, an easy path to monopoly. So I think the FTC should be doing a lot more using its administrative powers. And I'm going to talk in a moment about why I think the FTC should really claim the mantle of national competition policymaker. But I would be remiss if I didn't talk about the 800-pound gorilla in the room, which is the federal courts. So whenever I propose that the FTC do more, people will say, well, yeah, that's all fine and dandy, but the courts are really hostile to progressive administrative action. Everything the FTC does is going to be struck down by the courts. Legal risk is real. Like, there's no point denying that. The courts are hostile to progressive administrative action. We saw this last year with the Supreme Court's decision in West Virginia versus EPA, where they announced this new doctrine called a major question doctrine, whereby an agency cannot regulate a quote-unquote major question without clear authorization from Congress. What's a major question? Well, we don't really know. It's like obscenity. It's in the eye of the beholder. So it's important for us to realize that the courts are political actors. And at this point, it's hard to deny. In fact, I would say some of these judges have embraced the notion of being ideological actors, carrying out the reactionary Trumpist agenda. And so what can the agencies do about this? First thing is, they shouldn't just sit on their hands and say, well, the courts are going to strike down everything we do. We should just continue to sit on our hands and do nothing like we've sort of been doing for the past 40 years. I think that would be the wrong lesson. First, I think agencies should be thorough in whatever they do. They should be careful. And I think the FTC's proposed non-compete rule really exemplifies this. The FTC put out a 215-page document reviewing all the literature on non-compete clauses, both literature and evidence supporting the rule, as well as literature and evidence suggesting the FTC shouldn't do this rule. It's incredibly careful. And people who kind of reflexively criticize the FTC for doing this rule, in many cases, appear not to have read the actual document. The FTC seriously grappled with counter arguments before putting out this proposal in January. So that's part of the work here. Good lawyering matters, but good lawyering is not going to save us. Like, this is ultimately about politics. And the FTC is one small agency within the executive and administrative branches of government. This is going to require a whole of government approach by the Biden administration, whereby the Biden administration embraces confrontation with the federal judiciary. I'm afraid they're not willing to do that, but they should do that. And, New Deal experiences indicate that confrontation is what ultimately tames judicial oligarchy. So Franklin Delano Roosevelt famously did not pack the Supreme Court in 1937, but maybe more importantly, he did rein in the courts. The courts, in the famous switch in time that saved 9, abruptly went from striking down New Deal programs left and right to adopting a posture of restraint. And not just a restraint with respect to the New Deal, a restraint with respect to economic policy making by the Democratic branches of government that lasted for almost 40 years. So FDR was successful in taming the courts. So we need a president who is willing to stand up and say, enough is enough. We're a democratic republic, and key economic policy questions should be decided by Congress and the president, not by 9 robed bureaucrats. So that's a fight that's much broader than the FTC. But I think the FTC can play an important role by instigating some of these fights, such as through the non-compete. So going forward, I think the FTC needs to be doing a lot more. I think what it's done so far is a positive start, but we really need the FTC to take up this mantle of national competition policymaker, because that's what Congress set it up to do in 1914. So 100 plus years ago, we were also living in an era of judicial supremacy where the courts were saying the 14th Amendment codified expansive notions of freedom of contract, which means that Congress and state legislatures cannot establish things like minimum wage laws, overtime laws, rights to unionize. And Congress said, no, at least with respect to antitrust, we're going to reclaim power from the courts and vest it in this expert agency that will answer to us, and that's the Federal Trade Commission. And the Federal Trade Commission actually has very expansive authority to make competition policy. So I'm going to quote a decision from 1986. This is well after conservatives took over the Supreme Court, where the Supreme Court said, the standard of unfairness under the FTC Act is by necessity an elusive one, encompassing not only practices that violate the Sherman Act and the other antitrust laws, but also practices that the Commission determines are against public policy for other reasons. So the court here, I believe this was the Rehnquist Court or the Berger Court. So either way, a fairly conservative Supreme Court in a unanimous decision said the FTC has broad latitude to make competition policy. And accordingly, the FTC has the power to fix competition law. The Supreme Court has done real violence to the Sherman Act since the late 1970s. Diana and Zephyr alluded to that. But fortunately, the Sherman Act is not the only federal antitrust law in the books. The FTC Act is also co-equal to the Sherman Act and broader in substantive scope, as I described. So I think the FTC really needs to say that we are the lead competition policymaker in the United States, not the Supreme Court. So I think going forward, the non-compete rule shouldn't be this exceptional policy intervention. Rather, it should be part of a broader FTC effort done through things like rulemaking, adjudication, and guidance to crack down on unfair competitive practices in the economy and ultimately challenge corporate supremacy. And look, I realize the Biden administration is not going to fix this problem in one term, and that was never a realistic expectation. And people who thought that in 2021 were frankly being unfair to Jonathan Cantor and Lena Conley. That's too much to do in 4 years. The Chicago School took 30 years to complete its project. It didn't happen overnight. I hope our project doesn't take 30 years, but it's going to take more than one presidential term. So by next November, things are not going to be radically different. But I do hope by next November, the Biden administration has laid down a few important foundational stones on which future administrations and Congresses can build. Thank you so much.
Yeah. And then taking questions from questioners, and then at the end we'll give the panelists a few minutes to wrap up each with some final comments. Feel free to come up to the microphone here in the middle. For anyone who wants to give a question, I have two caveats on that. Questions have question marks at the end of them, so please do so accordingly. And they come in a one per customer fashion. So please introduce yourself and then feel free to give your question. Before we do that, just for the CLE folks who are here or watching, the second CLE code is Sycamore, like the tree, SYCAMORE. Please.
Yes, hi. My name is Stephen Spitz, and I went to the University of Chicago Law School. I had a guy named Ken Dam as my antitrust professor, who kept insisting it had nothing to do with breaking up monopoly. My question is very simply, how are we going to message that antitrust actually originates in the Sherman and Clayton Acts, where the trusts were the big corporations, and antitrust means that they were against the trusts and they wanted to break up the trusts? How do we get back to the whole idea that bigness is bad? Because not just economic power, political power.
So I'm going to ask maybe Zephyr to take this one, as she's written a book that's terrific called "Break 'Em Up" about this topic, among other things. So,
Mr. Spitz, this is a downhill battle. The hunger across all political, by the way, it's as Diana suggested, it's a bipartisan hunger, not necessarily on the elected officials, but the public hunger to live in a free society where you have the freedom to leave your job and get another job and know that those two employers are not in cahoots, where you have the freedom to start a business without being crushed by competitors. That is a wildly popular view, and people are wildly in support of aggressive antitrust and anti-monopoly behavior. Given the place that we're in, and I see that Senator Feingold is here, I think that ACS has an important role to play here. That there is also among law students a real hunger, and it's just one part of society, but a real hunger to understand what role they can play in this very exciting but hard moment, because we're talking about concentrated capital in a way that, world history has rarely seen. So we're up against some serious fights. There's a real hunger to learn old lessons, to say, take the Robinson-Pacman Act and enforce it, to learn a different kind of antitrust. You see that among students. And I think that ACS can play a critical role here in providing forums and more avenues for learning about both the history and the possibility and the challenges. Ganesh is working on a very exciting related casebook. One of the things that Brandeis was committed to was learning industries as they are. And one of the revolutions, one of the Bork's revolutions, was to make antitrust abstract instead of concrete. So what I see in my students is hunger to learn about who's making plastic straws. How does that industry work, as well as how is social media organized? A real kind of deep industrial focus. And ACS, I was on a panel here with Lena a couple of years ago. I think she was still a law student. But I think that there is still more hunger, that for this downhill battle to work, there's also maybe this metaphor is going to run out of itself pretty soon. It's like, snow machines trying to stop the way. The political hunger is there. The reality supports our view, as opposed to the abstraction of the Bork effort. But we actually do need to, at a law level, train law students in a different way of thinking. Train young lawyers in a different way of thinking, because those are the law students and lawyers that are going into that whole government approach that Diana is talking about. And if they're coming, having been trained the way that you were trained at the University of Chicago, they aren't going to see possibility in those fallow rules. They're going to say, this is just the way things are done. So we have a collective job it is bipartisan, but as progressives, to train lawyers in new possibilities, to bring the ball all the way down the hill. Did I finish that metaphor okay?
Great. Hi, my name is Driscoll Crabb. I'm a rising 3L at Creighton Law School. And I guess this question would kind of relate to the toolkit that you guys were mentioning. And so for the past couple of years, we've seen, CEOs on calls say, we can raise prices because inflation, we can just blame it on that, or workers' wages increasing. That seems to be clearly an antitrust problem. And just kind of connecting that kind of rhetoric and, fallback by companies that are in these oligopolies when, when the DOT or other agencies try to regulate these companies, I feel like it's a very easy excuse for them to say, oh, these regulations increased, now we're going to increase prices and just blame it on the agency. And I guess, is there an antitrust way to combat that sort of rhetoric and sort of just like public culture of accepting that as the norm? And I feel like I hear that a lot when I say, like, we should regulate them. And my mom will go, oh, that'll increase prices. And I'm like, okay, like, I don't have a great response for you, but so I just,
Sure. That's a good question. Happy to lend some perspective to that. So I've been in antitrust and competition and regulation for 35 years, and the stories have remained the same from large defendants who are promoting their mergers and defending their potentially anti-competitive conduct. There has been a decided lack of increasing sophistication, maybe outside the digital sector. We hear the same stuff all the time. Well, rising prices, that's inflationary pressure. That's just fact checking. We can fact check that in 5 minutes. We hear things like, we got to merge to get bigger, to compete better with our bigger rivals. That is not a legal defense for a merger in the United States system, but it constantly arises. Got to merge to get bigger, to compete against our bigger rivals. The logical end to that would be 2 firms in a market, right? Because I don't think a merger to monopoly would be tolerated that much. Another story we hear, well, we want to buy this small company because it's failing. It's failing, and it would exit the market anyway, and so there is no competitive issue here. We saw a lot of that after the pandemic, right? Pandemic-induced failures. So this series of rationales and justifications for why firms need to be bigger, why their anti-competitive conduct should be justified, really hasn't grown any more sophisticated. What we do see in digital now, of course, are security justifications for self-preferencing. Well, we've got to do this with user data. We have to set up these particular guardrails because we don't want user data to be violated. That's a little ironic because user data is the fuel of the digital ecosystems, and that is where the incentives to acquire and maintain market power actually reside. So I think a lot of this is education. It's educating the public, educating Congress and the enforcers, making coherent, deep dive arguments about why certain types of conduct and mergers are blatantly anti-competitive, why enforcers need to watch certain sectors for what's developing. We see developments over here, and we see developments over here, all worth watching. But what really remains incredible, but should not be amazing, is the fact that these defenses, the defenses remain the same, and that in itself tells you something.
Sandeep, do you want to add?
Yeah, so I think inflation is a really interesting example, and I think a little bit of a missed opportunity by the Biden administration. So some of us have been saying for the past few years that at least part of this inflation story is a monopoly and oligopoly power story. If you're looking at the source of inflation, for example, meat packing, so it's a highly concentrated industry, and it's evident that meat packers were exercising some of their pricing power and contributing to inflation. And then subsequently, other firms said, well, inflation seems like a nice cover for us to raise prices and tell customers, well, inflation's happening, so you just have to accept a double-digit price increase this year. And I think the White House pushed back against some of the right-wing rhetoric around inflation, which said, oh, COVID relief programs are simply too generous. That's what's causing inflation. It's a classic demand-side story. We need to cut social support, and that'll bring inflation under control. And rhetorically, the White House pushed back and said, no, that's actually not what's happening. But unfortunately, it didn't back that up with action, whether it was an antitrust action or a consumer protection action, going against some of these companies that were abusing their pricing power to contribute to or exacerbate inflation. And there was a really special moment, I think in late 2021, early 2022, where if this rhetoric had been backed up by just a couple of big cases, the public would have seen like, okay, the right is using this as pretext to attack social supports. But that's not what's driving inflation. This is a classic corporate power story. And that window didn't last that long. It was probably 6 to 9 months. And the administration didn't take action. And now, of course, people are saying, oh, actually, in hindsight, it looks like inflation was a corporate power story. But, political opportunities don't last forever. And I think the opportunity to tie inflation to corporate pricing power has more or less passed. And now even the Jason Furmans of the world are saying, "Oh, okay, yeah, maybe those dirty hippies were right. This was actually a corporate power story." But well, we've outsourced inflation control to Jay Powell. He'll take care of it, even if it means throwing millions of people out of work.
Good morning.
Hi, my name is Nicole Sammy. You all have done an amazing job of summarizing and giving background on what's happening at the federal level, but I'm interested to know what can be done at the state level and if there's any model legislation.
Great question. Someone who's not Zephyr want to take that question,
I can
given her role? So
start that.
Sandeep, maybe?
So I think there's a lot of exciting things happening at the state level. I think state legislators, state attorneys general, state regulators are really picking up their anti-monopoly tools and saying, we can, in many cases, replicate what the feds are doing, and in some cases, actually go beyond what the feds are doing. I think New York AG is doing great work, not to embarrass Zephyr, but it's really being replicated across the country. So I'll talk about the non-compete work. I think the FTC rule has understandably received a lot of attention, and I see Terry Gerstein is walking in at an appropriate moment. But a lot of this has been initiated at the state level. States have passed laws restricting or prohibiting the use of non-compete clauses. So Washington State in 2018 passed a law prohibiting non-compete clauses for workers making less than $100,000 a year. Colorado passed a comparably good law. California and New York are now debating bills that would enact full or almost complete bans on non-compete clauses. So there are a lot of things happening at the state and local level. And if you look at antitrust enforcement, the first big cases against tech didn't happen at the federal level. They happened at the state level. So California and the District of Columbia brought major antitrust suits against Amazon. States have brought cases against Google and Facebook. They're not faring as well as any of us would like, but there's real energy and excitement at the state level. And what's positive is, regardless of what happens in next November's election, I think we're going to have a certain baseline level of enforcement because of what states are doing. So even if we, God forbid, get a second term of Trump, states are going to continue to do important work.
So I think we'll have time for one more question. And so I'm going to ask, next person to ask one more question, and then we'll do a final comment from each of our panelists, and we'll have enough time to get everyone out to lunch.
Well, thank you. I appreciate that. It's actually two questions, so you can pick whichever one you want to answer. Yes, my name's Maxwell Pritt. I'm a litigator with Boyd Schiller Flexner, and I'm also the former chair of the American Constitution Society Bay Area Lawyer Chapter. So the first is on non-competes. I'm wondering if you think that organizations like ACS should not simply support the FTC's non-compete, but argue that it clearly doesn't go far enough. In California, I've litigated our non-compete law many times, and businesses are, they're smart. We have smart lawyers for the businesses. They say, okay, fine, we'll just put it in a business-to-business contract. And so you have businesses who have contracts with their customers who import the non-compete and say, well, now our customers, you can't hire anybody. It does the exact same thing, and we have to litigate it in the state courts in California. And the FTC's law is only an employer-employee agreement ban on non-competes. So, yes, the FTC passes that, and then you spend 10 years or a decade litigating how does that apply to the business contracts? And then the second question is just how do these antitrust and non-compete principles, or how do you think they apply in these so-called financial crises where the government seems to run around screaming with its head on fire saying, we're not going to consider any of those things anymore. We're going to sell off pieces of companies to the competitors who are already probably monopolies and creating larger monopolies that then we're still litigating a decade later on whether or not that was even constitutional or appropriate under the antitrust laws. Thank you.
Great. Someone want to?
So maybe I'll just quickly respond to the non-compete question. Fully agree with what you said. I think the FTC proposal is really strong, but it's actually not strong enough in a couple of important respects. So you mentioned one, it doesn't cover restraints among firms where, McDonald's tells its franchisees, you will not hire workers from another McDonald's restaurant. The rule doesn't cover that. Second, the rule doesn't fully prohibit what I call functional non-compete clauses. So things like liquidated damages provisions where a firm tells its workers, if you leave, you have to pay us $10,000 or $50,000 a year. So yes, it's formally different from a conventional non-compete clause, but the practical effects are the same or sometimes even worse. And in our comment letter, as well as some public writing we've said the FTC actually needs to prohibit these contracts as well. And if the final rule doesn't, companies are going to exploit what I think are actually fairly significant loopholes. So the proposal is a good start, but the final rule actually has to be broader and stronger. So I would wholeheartedly support ACS advocacy around this. Putting friendly pressure on the FTC. Like, this is a good proposal, but you didn't quite go far enough.
Anna?
In response to that.
Did you want to jump in? Okay. Great. Another final?
Oh, is this final?
No. We'll get back to it. I just wanted, if you wanted final thoughts on the non-compete question. Okay.
ACS, just general. Biden says this is a failed experiment. Last summer, he says it's 40 years. It's been a failed experiment. Love it that ACS cheers that on, but ACS should be so far ahead of that. Like, we have an opportunity to set the standard, and that we have a willing administration, but it really matters when an organization like this sets the standard. On crises are really important, and we're not done with crises. So step one is COVID showed another kind of brokenness of the last 40 years. COVID showed that when you concentrate supply chains, you risk people's lives. That when you concentrate industry, people will die because you cannot start up fast enough. And that the more that you actually have competitors, you have opportunity for health safety. COVID also showed what we've seen for some time is that when you concentrate industry outside the country, it's a national security risk. So that anti-monopoly and trade are tied together. But we have a history. And what's her name? Mariana Mazzucato has these wonderful books about a vision of what government can do, an active, creative government. In those moments, the Defense Production Act, a sort of vision of government, not using it as an opportunity to concentrate, but stepping in. And that is not incompatible with the political economic vision of the anti-monopoly movement. It's not like we're all just supposed to sit back. It's that, when there's a crisis, we have a responsibility to keep an open, free, and safe economy, including during crises. And that means stepping in and using our DPA-like powers to provide services, but not using it as yet another excuse to just concentrate.
So we're we're basically out of time, but I promised I would give our panelists one final word. So maybe we can go down the line, take 30 seconds to a minute for your final advice or thoughts to everyone here about this new era of antitrust. Sandeep, do you want to start?
Sure. So I'm just a simple DC lawyer. I live in DC, so I can't say country lawyer. Right now, we have an anti-monopoly network. We have loose constellation of advocates, professors saying this is important. Anti-monopoly can help build a fair, equitable, and small d democratic society. We don't have a movement yet, and I sort of cringe when I hear the term anti-monopoly movement. I think it's premature, presumptuous to say we have a movement yet. So we need genuine grassroots organizations involved in this, and that includes labor unions, small business associations, professional groups. We need mass support for the work that we're trying to do here. And, we're doing this mostly on the inside. We don't have anything like what we had in the late 19th century where workers, farmers, ranchers, artisans came together and demanded national action against the railroads and the trusts. We're not there yet. This is still very much a top-down effort. And if this work is going to be sustainable and lasting, we need that popular movement. We need politicians to recognize that people care about this. And I think Zephyr is right. There's, at a minimum, a latent coalition for this work. People don't like Comcast. People don't like Pfizer. People increasingly don't like the tech companies. And that's a noticeable change from 10 years ago, where these companies were the darlings of Washington and really much of the nation. So there's a latent popular coalition, but coalitions don't just organically emerge. We need organizers to do that work, to turn potential into actuality. And unless we have that, I worry that some of the things that have been accomplished so far are going to be fleeting and quickly forgotten once there's a change in administration. And this is going to take a lot of time and effort. But I think over the long run, over the next 5 to 10 years, we can actually generally build an anti-monopoly movement such that politicians are generally scared when they do pro-monopoly things, when they think, oh, it might be easy and expedient in the short term for me to support this merger or to support this deregulatory effort, but there are going to be practical consequences at the next election. People are going to hold me to account, and that's how things once were. And I think we can have that political environment again, where people are afraid of being perceived as shills of big business.
Dana?
Sure. I just have two quick comments to leave you all with. One is, if you're planning or want to get more involved in promoting competition, I would focus seriously on the importance of making evidence-based arguments. Hand waving is ultimately not going to work in the courts. It's going to be evidence-based. And so the work that AAI has done, the legal, the economic, the institutional, the business work that we have done, really focuses on building an evidence-based case for more progressive, the progressive movement, stronger, modernized, more clear antitrust enforcement. And there's one really good example of that, and that is most litigated merger cases that should never have been allowed are won on the basis of vacuous arguments about why mergers are pro-competitive. The courts have bought into this for years. These are uncertain, dynamic, long-term benefits that never materialize. We just proved this empirically in AT&T Time Warner. And they undid the deal 3 years after they did it, after going to federal court and arguing for these long-term innovation benefits, which never happened. So evidence-based case is really what's going to win the day and support you and your organizations in this broader debate. Second, absolutely appreciate and understand this unique system of antitrust enforcement in the U.S. We have private rights of action. Private enforcement is huge. We have the states. The states are the underdogs. They need to come to the surface, and states are differently resourced with antitrust resources. Some can only do bid rigging cases. Others are very sophisticated. And then we have public enforcement. It is absolutely a unique system in the US, which is designed to work collaboratively and together. So please, please, please understand and pursue that three-part system of antitrust enforcement in the US.
Final words, Zephyr.
To antitrust being primarily a election law, anti-corruption lawyer. And I came here because I think there's a lot of fights going on. But one of the most central threats to democracy is the threat of corporate tyranny. And as in that area, the most effective rules, there's big cases and those big cases matter. The merger review absolutely matters. But as with anti-corruption work, the most powerful rules in my mind are the rules of the road that are bright line rules. The rules that say you can't give more than $5,600 to a candidate and you can't have a non-compete. So when I look at the opportunities in the next few years, it's around rulemaking and legislation that is focused on those bright line rules. Because those cases that Diana is talking about, those hard-fought cases, you got to bring the evidence to those fights. But we need also to have a clearer law-based system where there are just some things you can't do in a system of law. And the last thing I'll say is this is super exciting and the stakes are really high. Because we already, prior to the last 6 months, we're in a moment where big data is really changing the power dynamic. It's changing the capacity of companies to figure out just how little I can pay you. To figure out just how much I can charge you for a Taylor Swift ticket because you are a true Swiftie. But when now you add to that AI and the power of AI, it is critically important that we engage in taking on concentrated power, because you add concentrated power to AI and the capacity to discriminate, and these are discriminatory tactics, the capacity to discriminate. We need even more strength than we had 40 or 50 years ago to make sure the people in this country have the freedom and the dignity they deserve.
Thank you, Zephyr, and thank all of you for joining us for this panel. We encourage you to stay for the rest of the day and come to a lot of the other events. And please be active in your local chapters wherever you are in the country. Thank you all.